Good evening and welcome to the 3-day workshop on career in intellectual property rights. So, as you know, these sessions are going to last from today, Monday, tomorrow, Tuesday, and on the last session will be on Wednesday. The first two sessions will be conducted by a very eminent personality. I will bring them on stage within a few seconds. So today we have with us Dr. Anindya Sircar. He is currently the DPIIT IPR Chair Professor at Nalsar University of Law, Hyderabad. He's also engaged in consulting, strategizing, and teaching programs in the field of intellectual property rights. And he has more than 20 years of experience in the industry before being an academic and teaching about intellectual property rights. So he was for more than 5 years an assistant vice president and IP head of Infosys. And for more than 13 years, he was in the IP department of, of Biocon Group. So Dr. Sarkar, he has a unique distinction of having two PhDs, one in science and one in law. And during his long professional involvement in the IP field, he has worked extensively within IPR acquisitions, IPR licensing. So, folks, everyone who is joining us today, make sure you have your questions ready. Make sure you pick the brains of Dr. Anindya Sarkar. And with this, I will invite him to the screen and welcome him on stage. Uh, Dr. Anindra, thank you so much for joining us. Real pleasure to host you. So I think the audience is now really warmed up and waiting for the session. So thank you very much. The floor is yours. I am around in the backstage.
Good evening, everybody. It feels really good to be here and talk about the sessions, especially in careers. Now that IP is gaining importance, and the more and more people are getting interested in having a meaningful, fruitful, and a successful career in IP. So, what we were going to do is that we're going to break this thing up into maybe two portions from my end, and we'll focus initially for the job functions for non-lawyers, and then probably later part of the talk we'll talk for lawyers, and specifically for lawyers. So it's going to be a good mix. Uh, the way I would like to do this thing is probably uh, give a presentation with a slide deck, because that's a formatted way of doing things. Followed by, we'll take questions once in a while, and probably devote most of the time of tomorrow into one-to-one queries, so that we have a background ready today and maybe a little bit of tomorrow. That doesn't mean we're not going to take questions today. We are going to take questions today as well. Okay, so with that, let's try to put up the. Yeah, we go. Hmm. So I represent Nalsa University as being the chair professor of IPR there, and I do parallelly carry out consulting and other activities on my own capacity. So to start with, when you say, see, I don't want to present to you, IP is something very, very tough and legal stuff. You need to know uh, so much of law, so much. You need to know. But remember, IP is one part of the legal activities which is commercial. Okay, this is the one which is the commercial part of it, which requires people from various backgrounds, different backgrounds, to come in to make it really, successful. So how is that? I normally start with this kind of a picture that IP needs to be created. Once it's created, there is to be an application to document the IP, and it needs to be protected in some manner, and then it can be used as a successful business. Okay, this protection is not protected, unprotected, it may get lost. Now, in this entire cycle, you'll find there are various job functions which are a profession by themselves. Okay, which are so. I mean, I find many of them or most of them so exciting that that are often not looked upon with that much of importance and focus. Just to give you an introduction, what do we mean by IP? IP is a group of legal right that provides protection over, for a certain period of time for what one creates or invents. Okay. The main three forms of IP which are popularly and most widely used are copyright, trademark, and patents. However, having said that, there are, according to TRIPS, there are many more additional forms like geographical indication, industrial design, integrated circuits, trade secret, plant varieties. I have also added one more there, which is not really a defined as a form of IP, but I have also added their contracts because I feel contract is an integral part of doing business with any of those forms of IP. So good understanding, good handling of contracts is always going to be beneficial. So let's spend one minute on what each of these mean. Okay, what does copyright mean? Copyright covers all fine type of creative expression. It could be literature, music, cinema, drama, sound recording, softwares, oh, flower arrangement, dance choreography, so many. Trademarks covers the various signs of enterprises used in products and services. Like you can see, you have a trademark of Turnip right on the corner. Okay, that is actually trying to associate this program is uh, partially created by this organization. So you normally connect it with a product or a service, and which leads to a certain amount of expectations. Okay, like when you use a certain brand of soap, there is a kind of expectation. You use a certain brand of perfume, there is a certain expectation, and so on and so forth. Patents covers all the form of inventions that are and the process involved in such. So these are inventions. Inventions are stuff which is overcoming a certain problem and it's being done for the first time, and you can take a protection of that in the form of patents. GI or geographical indication, which has been given a tremendous push and importance all through right now, especially by the government of India, which is a community right which can be given to the products, which is indicative of their origin. Like when you are drinking Darjeeling tea, it's not going to taste like a Sam tea or Nilgiri's tea. So Darjeeling tea is associated with tea grown in the foothills of Darjeeling. But those are rights which are given to the communities. It could be, it could be sweets, it could be textiles. Okay, like the most popular ones globally are like Scotch whiskey, champagne. Okay, then Rockford cheese, which is another very famous one, which is given to the origin because the origin plays an important role. Industrial designs, these are non-functional elements. Okay, these are design which appeals to the eye. Okay, you like a car because it looks like that. You like a mobile phone because it looks like that. The design element is like this. Okay, where the functional parts are already taken care of in the patents. Now we are looking only at designs. Okay, in case of integrated circuits, these are the these are the various chips which are being used. Trade secrets are in bits and pieces of information which are confidential, okay, and owned by certain individual or organizations, which could be which helps them in their business running. Okay. Now, plant varieties are those plants, seeds, trees, vines which are asexually reproduced. And contracts are a legal binding agreement which are enforced by law. Okay. Now, this is a very, very big background of what are the elements of IP. It's important to have a clear understanding of them so that when we talk about caveats and copyright, caveats and trademark, you'll be able to be, we'll all be in the same page that what is that we are dealing with. Okay. So there are elements of IP which will come in, there are management of IP which will be coming in. Okay. And each of them could lead to a career path. Now, if you want to look at the complete IP cycle, then this side you have the IP generators, this side you have the IP utilizers. They can be the same. I mean, you can generate your own IP and you can utilize it yourself. If you ignore it, is lost. Now, I'm not reading, have a look. There are so many functions which are involved in the complete IP cycle. And they are not just simple, they are all professional work. And when we talk of IP cannot be spoken or treated in isolation. Okay, because IP, it's a very strategical part. You need to integrate it with your research and your business. If the research is not producing IP, the right IP which is required in the market, it is of no use. And if you do not have a proper business strategy to implement, to commercialize in the current market, you would be missing out on the right game. Okay. So it must be integrated. One should speak. They cannot work in silos. One should speak to each other. Hmm. And the third part is that you need a proper management team to manage it. Okay. And which it's like managing anything and any activity. IP management is also very crucial and critical. It works in a pyramidal manner. I have actually taken this photograph from a book. It's a very nice book. If you get a chance, read it. It's called Edison in the Boardroom, where it says the management starts as defensive, where it is more or less is that I'm not infringing anybody else's IP. Then it moves to cost control, where you start moving out from a cost center gradually to the next level to a profit center. And by the time you have all the other functions integrated in your uh, management system, and finally you lead a visionary space where you are probably benchmarked and everybody wants to follow the way you would like to function. Now, see, IP management is a very, very integral part. If you do not manage your IP properly, it is pointless to have IP. Your research may be doing great job in bringing things up, actually supplying to the market need. But if you do not have a proper strategy and a proper planning of that, how to commercialize it, then it becomes only of academic interest. And IP in the law, in the overall things of place, is not something which is a primarily academic interest. No, it's not. Okay. IP is a very strong business tool to be used. Okay. And if we do not use it properly, then the entire exercise where your resource, your time and money is of no use. With those things in which, with in mind, specific and several job functions have cropped up. Okay. Now we are talking too much about startups. There are so many entrepreneurs here and there. Every second person I meet is now an entrepreneur. And in this startup category, IP is often ignored the most because there is a constant requirement, constant rush of competing priorities and of the financial requirements. Okay. So IP management, two other thing is which is it's a game between value and risk. It's a game between value and risk because what you want to do, okay, in most businesses to increase your value, okay, and reduce your risk. So you want to maximize your value of the IP and at the same time minimize the risk of that non-violation of others' IP. Else that person is also going to sue you. For that, what do we need? We need to have some practices. We need to have proper policies in place to protect their own, where your own IP is protected. Now, now, at the same time, you respect others' IP. See, if you follow slowly, you'll find that these are all career paths. There are people who are doing it in house. Then you have the compliance team, which is usually cross functional. That total compliance is maintained. You need to maintain confidentiality by restricting access, and you have to have proper employee employer agreement in organizations and security through physical or electronic means. Then comes that to the previous one was the value part. Now if you look at the risk, you have to have a proper means of risk assessment, risk mitigation. You have to do a survey, a study on what is the market doing, how many other unexpired IPs are there, how many patents are there, am I falling into the trap of somebody else? By and large, this has become one of the biggest area of work. And of course, training is something which certain individuals do, which we are trying to do even today. Hmm. Then you need to monitor your activities so that compliance and de-risking is being done. You need to track and implement your improvements. Now these are job functions, this is which I'm telling you in this way that if you get a chance to work in-house in a corporate, these are some of the functions which are there. And some of them are very, very exciting. So if you choose IP as a career with that background, let's more focus on what kind of stuff you can look into. If you look at the assets, the intangible assets, they make up 80% of the business value. It is important to capture them, catalog them, qualify them, protect them, and use them for your commercial benefit. Now, these are very, very high level or top level words. There would be a tree which follows below. When I say, what do you mean by capturing IP? What kind of work is that? Do you have you implemented effective processes? Okay. Are your enforcement things? Are you checking that your IP is not getting infringed by somebody else? So, as a non-lawyer, if you want to, we'll focus on the non-lawyer part first, then we'll focus on the lawyer first. As a non-lawyer, what do you require? You require a technical degree, not a law degree. Okay, a degree in STEM or a scientific or a technical qualification, okay, which is far more specialized. You may get into some of the more um, niche areas. Do you require a PhD for this? My answer is no. You do not require a PhD for this. Some firms prefer give importance to PhDs, but it's not a requirement. Okay. It might give a definitely an edge because that kind of formal scientific training does have some influence. The other thing is that many would like to become a patent agent or a patent or a trademark agent. Now, what do they do? These are the people who handle patent and trademarks with the patent office and the applicant. Okay, they are the ones who work in the law firms. They are once you are a patent agent, you can sign documents. You can represent your party. It is like a lawyer representing their case in the court. This is a patent agent or a trademark agent representing their case in the patent office or the trademark office. And there's a huge opportunity here. And what do you require for that? You just have to be 21 years of age and must have a degree in science and technology if you are going for patents. If you are going for trademark, it could be any degree. Need not be science and technology. Need not be limited to science and technology. Okay. And it is not only getting the proper background, then you need to train yourself. How do you train? How do you get into this path? Okay, you can the standard way which most of our jobs function in normal office. You shadow a senior, learn from their colleagues. There are a lot of informal lectures and workshops, master courses, examinations. There are postgraduate diplomas from different law schools like National Law School Bangalore or Nalsar, and there are some from private establishments. Hmm. And you do need to do a lot of reading. Now, if I look in the last few years, we have had so much of training and awareness programs on IP, which we did not have for the 2 decades. There's too much going on. Okay. So you can take a look which suits your requirements, your need, and get yourself. Many of them, are available for free. So, beside that, what kind of skills should one build up? Having a formal education is never enough for any job function, including career in IP, because IP field is very demanding and it requires you to be up to date. Okay. So, what can add up to your skills and make you a better IP professional is advanced understanding of science and technology, improved communication skills, skills in legal terminology, good reasoning power, verbal skill, analysis skill, critical thinking skills, and interpersonal skills. Now, these things, as you get into, I mean, it's like you jump into the water and you'll swim and you'll learn all this one by one. If you are conscious, then you learn it fast. And if you learn it fast, your progression is faster. So, what are the career options? What can you look for? If you are not from the legal background, you can look for private practice, work with clients. You can start as an associate and become a partner and then move to an equity partner. Here, the debate often comes that you can whether should we look at big firms or small firms. It does not matter. You should start at a place where your learning is maximum, where you think you'll be able to learn maximum to build yourself at the initial stage. You can work in the industry or corporates as inventors, people who manage IP, play strategic role, hmm, carry out licensing agreement work. You can become an examiner of IP in the Indian Patent or Trademark Office. You can do paralegal work, get into research and academics, or even get into consulting activities. So, which are the major employment areas? It's computer software technology, biotechnology, education institute, libraries, pharmaceuticals, healthcare, films and television, publishing, music, government offices, or your own if you want to set up your own shop. See, the entertainment industry, which is music, the cinema, the television, films, etc., has a huge requirement of IP professionals, which is not really very open because copyright is very, very important. Copyright, performers' right, broadcasters' right. Okay, just yesterday a bill has been placed with the new uh, with amendments for broadcasting. So those are areas where which is um, not only exciting but also some find it very very glamorous. If you want to be in prosecution, people who are very deep in science and technology often take up IP prosecution as a profession. They qualify as agents with a patent or trademark. And what kind of work they do? They are into search and analytics, drafting of patents or documents, drawings, taking care of office formalities, filing and registration, response to examination report from the IP offices, attend physical hearings, mm, participate in oppositions, file or defend appeals, take care of the fees, renewal and maintenance. Now it looks like a bucket of activities which one does. In bigger areas of functioning, each of them is a specialized job function. Okay, what does that mean? That means the guy who's actually searching and doing analysis to find whether a certain invention is protectable, patentable or not, is most of the times not the person who's drafting. Okay, the job volumes are high. But there are cases where one might get the opportunity in a firm or in an in-house practice to do multiple of these functions. It is helpful if one is exposed to most of these functions and then specializes in one or more of such activities. Now, in today's world, when any invention is happening or anything is getting built, there is a common fight, common dilemma whether I want to build this or I can buy this. Now, this dilemma between build and buy is usually dependent on your timeline, skill availability, research, development costs, market opportunity, so on and so forth. Sometime organization doesn't want to spend time to build the entire thing, they will buy part of it. Okay. There comes the importance of IP, how clean stuff you are buying, clean in terms of clean in IP, what to sell. If you are on the other side of the table, what kind of monetization you want to make by selling them to others? Will it affect your market share, or by selling your own, by selling your transferring your technology or selling your IP to somebody else? Are you giving birth to your own competitors? Okay. These are again some of the critical things to keep in mind. So, in terms of reality, what happens in the ground, it is no longer buying and selling. It is all licensing. Okay. Like software, you don't buy a software, you only license a software for use. And there is a huge opportunity to work on those areas on IP license. Today, technology, just technology transfer, technology licensing, or is ineffective, is useless if the IP is not taken care of. It is primarily a transfer of IP. It is primarily an assignment of IP. Technology automatically goes. So when I say that's what I was saying. When you look at technology, that's not technology. It is usually broken into two parts: the capital and the property. So it is important to have the right skills also. Okay. So this is how I have tried to represent this. And in an IP licensing, everything is important. The degree may vary, but everything is important. Now let's look at some of the very, very precise professions which a non-lawyer can take up in IP practice. That's first is IP discovery. Now this is your bag full of your IP, which aligns with the business goals which you have in mind. Okay. So one usually does a proper analysis of this and sees what should be protected and how, in which forms of IP should be protected, and develops a strategy to gain commercial benefits out of it. Now, this is some place where usually most of the technical guys would love to work. Okay. And some of them are also part of the research group which generates that IP. Okay. Then we look at IP strategy and operating plan development. That's you build a proper strategy, how to function your IP, when will be your product launches in different territories. It is not that today I want to launch a product in India and next month I'll launch in Germany and the month after in Japan. You won't be able to do that. Assuming that you have all other things in place, there will be a lot of existing IP in those areas which will stop you from doing it. That timeline planning is also very, very important. Okay. And how do you optimize your bucket of IP? By doing a constant evaluation and seeing that uh, how to increase, how to fill in the gaps, and at the same time, you can abandon IP. If you in your bucket there is some IP which is of no longer any of much use, why pay money and maintain it? So there's a group of people who are constantly working on it. Now visualize a situation where we are not one or two people. We're not talking about four patents and two trademarks. If you say, for example, I'm looking at a company like IBM, they have about 4 to 5 lakh patents and few thousand trademarks. Managing that is not easy. Now, I've given you a very, very big example. Modern side companies even have several thousand patents. It is a constant endeavor to maximize and monetize them as much as one can. Then comes the area of risk management and freedom to operate. See, freedom to operate is a jargon which we IP guys use very frequently. That means, do you have the freedom to sell? Now, you may ask a question, I made this product, what stops me from selling it? IP of others is what stops you. Now, all that checks and balances has to be done. If you don't do that checks and launch a product in a territory, in a geo where you do not have a freedom to operate, it will be very, very risky, and you might have to pay damages and might have to visit uh, the courts. The other important part here is innovation capture. That is, many a times, very common in startups, there is a lot of innovation which is happening. Okay. And we are not able to capture it properly. It is getting ignored. So you need some skilled people to constantly look at what's happening, each steps, each process, each development every day on a regular basis, and ensure that they are captured properly. Okay. Sorry. That was the prosecution part. If you get into strategy and execution, there's an IP advisory, which is constantly supported by the business team, the people in the field, on what is the demand, and you accordingly form the advisory statement on how this IP should be developed, which product should go out, which process should be employed, which should be discarded. Yet another area is competitive intelligence and IP portfolio benchmarking. Hmm. That is understanding the IP dimension, not only of yours, you're in the marketplace, and what we do, we usually prepare what's known as a patent landscape or an IP landscape and see the landscape in that area and accordingly take out your um, study. Okay. Then IP services for startups, these are usually at a very small level. It's done at a very small level, and because the workflow is less until they attain a certain size. Okay. Now, the most important thing is in a startup is the timing of the exit. Okay. If you want to give it up to larger players, and this is usually controlled, and the value of that depends on your IP. See, I meet a lot of startup people here and there, and do a bit of consulting in that area, I have seen that IP is totally ignored. Okay, in this by the startups until they reach a B level funding, or a venture or an angel funding at a second level. When you go, the promoters and the funders, or rather the investors, the first question they ask is, what IP do you have? Hmm. Then I see that many of them run helter skelter. Some of them, one of them once came to me and said, "Sir, I need some IP. No, look at my work. Can you tell me what to do?" You should have planned it earlier. Okay, when you have a brochure for your product or a process coming out from a startup, your executive summary should, in detail, talk about your IP, and that's what is going to give you the money, more money, I would say. Okay. Now there are transactional rules, which is IP audit, IP valuation, IP due diligence, IP licensing, so on and so forth. What do I mean by IP audit? See, if you are buying, selling, or valuing an IP, one has to do an audit. Okay, this audit sounds very much like a financial audit, but is more of a technology audit, and the IP present, absent, licensed, and whether it is clean or not. Then you have IP valuation. If you want to sell IP, you have to put a figure to it. This technology is worth X million dollars. From where do you get that X? So there are various valuation models available to do that. And then there is a negotiation process which happens during the licensing, which is part contract, part marketing, part valuation, all put together. Now, if I want to buy your IP, I would like to do a due diligence to see what you are trying to sell is exactly what you want to sell. So I want to understand the value, okay, before acquiring that. So there is an IP due diligence process. Then there is a technology disposal and acquisition function, which means that sometimes we want to dispose of technology or business segments, sometimes we want to acquire. And remember, each of these are proper job functions. Of course, once you have a lot of IPs, a lot of license, there's a license management required. Then there's a research and scouting management. That means you try to find out what mm, what are the other IPs available which you can acquire to minimize your entry into the market time. There are several brokerage firms which deals only with IP, which gets you this done. Your job of acquisitions, your due diligence work. So that comes under the head of IP brokerage. And I think we should gradually take some questions right now. So I think IP management is a hidden career for all STEM graduates. I think let me stop today right now um, and take some questions. I think we'll get into more interesting areas tomorrow when we look at the commercial part of IP and what one can do in this area, along with some specifics uh, which which only lawyers can perform. Okay. So till then, I'll say good luck and let's take some questions. Are there anybody to ask some
Yeah,
questions?
so I can ask some questions to break the ice a bit,
Sure.
and then maybe the audience can also start asking their questions. We have a good amount of time, so folks, I I recommend everyone pick the brains. Sir is going to give you at least 20-25 years of experience in this field. So, sir, I wanted to ask, since students, we want to actually also encourage students to take IPR as a career. So, after they finish, suppose a technical degree, suppose they've done a BTech 4 year engineering. So, what they can do for specifically to enter IP? Is the patent agent exam the only option,
No,
or
no. In fact, I will not recommend just after engineering to take a patent agent exam because your exposure to that field is far less.
Mhm,
Okay. Now, there are many organization which takes graduates and postgraduates in science and technology in their IP field based on the area of the business. What I mean is that if you have done an engineering in automobiles, you might be absorbed in an automobile industry in the IP department. That's where you see that's the earn value learn model you get from in-house. If it's not possible, there are several good diplomas. Many of them are not full time. Some of them are full time as well. Okay. These are basically postgraduate diplomas on patent law, cyber law, mm, mm, or maybe today we are AI is influencing everything, AI and even data privacy. These are good diplomas from good places where you actually fill in the gap which is required, but which is not part of your undergraduate curriculum. And once you are doing that, suppose after your science and technology degree, you get into a diploma course, you'll get enough exposure which will help you to write a patent exam also. Okay. Otherwise, the theory and the subject part will remain new.
mhm,
So that's one of the ways of getting it, and many people do that. There are fortunately there are many IP law firms, boutique law firms which deal only with IP, are recruiting such science and technology background people
mhm,
at large numbers, more than they are recruiting lawyers,
mhm,
because they feel some of these activities are better done by with in-depth understanding of the technology.
mhm.
Lawyers can take care of it later if there is a litigation. Okay.
Absolutely, sir. Great insights, really. So, so another follow-on questions until, sir, let's say, if audience has any questions. So, sir, suppose these things you mentioned like IP audit, IP valuation, what can can students or somebody who's entering the job market, can they prepare themselves for these kind of roles, or are these roles for a bit more experienced professionals?
See, experience adds value to any job function. Okay. See, when I was in working in the corporates, and the first day when a new recruit used to come, I used to ask him, "So, which area would you love to work?" And 99% of them used to tell me IP valuation and IP licensing. Now, that's a sought after area.
Hmm.
Okay. But there is some homework to be done before you really jump into that. So these functions usually do not happen uh, individually. They are a team which works. Okay.
Hmm.
So the idea is, one gets a part, part of that team, and gradually to start taking more and more roles in it.
Hmm.
If somebody feels that today I'm out and tomorrow I'll go to join a company and I'll do evaluation and licensing, that's never going to happen.
Hmm.
See, because the money at stake is not a few hundred. Usually it's in millions.
Hmm.
And an organization needs to have confidence in you and your training and experience. So before they allow you to take a decision of such high amounts.
Hmm.
But
Absolutely.
it's a very, very exciting area.
Yeah, yeah, yeah.
And it is increasing so much that because
Hmm.
nowadays licensing is so people are don't want to waste their time, or rather they want to minimize their time to market.
Hmm.
So instead of doing developing everything, especially in the ICT industry, there is a huge licensing happening. I think there's some question from
Yeah,
Sumit.
yeah. M. Someshwar Rao, he's asking if a research in a research paper, if some research details are given, but the IP is not filed, is there any possibility that someone can file a patent on that research paper and commercialize it?
Uh, I assume you have disclosed all the details uh, in that research paper. That means reproducing the disclosures in the research paper, one can read to the product of interest. Now, this is a very, very damaging situation which has been done. If you file a paper, it creates prior art. That means it is no longer new or novel. If it is no longer new or novel, you cannot patent it. Now, who cannot patent it? Anybody. And that includes you also. Because some third party cannot patent it because it is already it's there in the public domain, the information. And you cannot patent it because you have uh, made it, you have killed yourself. So, what is the way of going about? First file the patent, then publish in the research paper. Okay, and research papers, what I understand are journal articles, are totally. Your next question is totally different from patent applications. So, after filing a paper, it is not possible to file a patent because see there are three primary requirements of patenting. One is novelty, inventive step, and utility. You have killed on the novelty. Having said that, I will say there is a saving grace somewhere also. The saving grace is there. Some countries, there in their patent offices, allow a grace period, a grace period of 12 months. That means if you are making a disclosure about an invention, you have a grace period of 12 months to file a patent. That is only to you. No third party can do that. But that's a risky venture. Okay. That's a fallback option if something has happened. Okay. That's not should be the practice. The practice should be that you file a patent, then go for a journal article.
Mhm. Yeah, yeah. Let's take another question. If I add other law person's views in my research paper, is it plagiarism? I think he means adding someone's views.
See, plagiarism is something which comes under the law of copyright. Okay. Now that means if you are lifting stuff from somebody else's creation without acknowledgement or permission, that is called plagiarism. But views can be lifted or reported that um, according to Rahul Kapoor, published in journal now so and so, okay, IP is going to increase in India. IP professionals are going to. So this is what I'm taking his view, giving him the credit, and also telling you where it was published. Okay. Now, how much can you lift from a book or a paper? 10% or 1,000 words, whichever is less. Okay. If you want to lift some music, it is 3 minutes, or 10%, whichever is less. So for every category, there is something which is known as fair use. This comes under the category of fair use. You can use it, but with proper acknowledgement and permission.
Mhm.
That's why journal articles, have an idea of references, footnotes, where you acknowledge the source, if it is not your view. Does that make sense?
Yeah, it's a great technical answer, sir. Thank you. I think I have one more question. Maybe it can be the last question if the time runs out. So feel free to ask if from the audience we can take maybe one more question after my question. That is. Sir, what could be some interview questions that you might ask, say, somebody who's walking in for an interview uh, for for some role in the IP domain?
So there are two differences here. One is that I would have totally different sets of questions for an academic role and for a corporate role.
Hmm.
Corporate role, usually goes on a skill mapping basis.
Hmm.
Okay, and the guys who take interview in corporates, technical interviews are usually guided by the CV you submit.
Hmm.
Okay, 90% of the questions are asked on what you want them to ask,
Hmm.
what you have written in your CV, and your answers to those questions lead to other questions.
Hmm.
So it is not going to be same. If somebody says, I'm very good at drafting, I've drafted some 50 applications, naturally the question will be on drafting.
Hmm.
And how you answer those questions leads to the other question. Okay. By thumb rule, I can tell you, I've interviewed thousands of people. Your initial questions are guided by your CV. You can actually make those questions, make him ask those questions. Then it will be a role fitting question. What the role demands and how much you fit on that role. And of course, lastly, HR will do the most important, uh, you know, compensation discussion.
Yeah, yeah, always. So, all right, maybe one last question, sir, from the audience. What is the life of a patent in years during which other cannot make such a product?
It's usually 20 years, 20 years from the date of filing. That's a global stand. Uh, it's the day you file or the day you make your first disclosure. mm, You will be filing patents in several countries. So it's not possible to file the same invention on the same date in different countries. So the day you have filed your first, from that date to 20 years. But there are two other schemes. Okay. One is known as patent term adjustment. Okay. That means if for some reason the patent office has taken a longer time to grant you the patent than the usual average, they'll do a term adjustment and give you an extension beyond 20 years. Indian patent office does not do that. But overseas, you're filing a US patent, a European patent, you'll have a patent term adjustment. Then there is another mm, extension which is possible in US that is known as patent term extension. The earlier was adjustment, this is extension, which applies to only pharmaceutical products. Okay. Because you make your product, you file your patent, you cannot sell the drug tomorrow in the market because you need to do clinical trials, right? And why do you do a clinical trial? See, people will give all answers. It will be efficacy, dose, this, that. The straight answer is government is forcing you to do clinical trials. Without that data, you cannot. So the government is actually also indirectly stopping you from using your own patent. So if that in that case there are certain extensions which happens in pharmaceutical category in the US, which is known as Hatch-Waxman's extension, but only in the US, not in India. But overall, you take it 20 years from the date of filing. I think you're not audible.
Yeah, beg your pardon. So thank you everyone who has attended the session today. As you all know, we have 2 more days left in the workshop. So tomorrow, Dr. Anindya Sircar, he is going to extend this discussion. So tomorrow he will extend the presentation towards more oriented towards lawyers, and also he will have an extended Q&A tomorrow. So make sure that you have your questions ready. And the day after tomorrow, I will also take a session on patent research and analytics. I've done research on patents. I've done consulting. I've done many search and technology commercialization projects. So I'm also going to share the soft skills as well as the things that you should learn to increase your chances for a career in IPR. And so, yeah, we will continue our session tomorrow, sir. Thank you very much. I wish everyone a great evening and see you tomorrow.
Thank you. See you tomorrow.